Alex here with a legal nuts and bolts video on private communications. I really don't know what else to call it because this is another question mark video, another myths video, dispelling a myth. Um, the two ways that I get these questions are number one, my ex, family court context, said they were recording me and I told them they don't have my permission. And then number two, like at an exchange, also family court context. This applies to everything, but these are the emails that I get. But my ex shows up at like a custody exchange with a camera and records it, and I don't like it. Those are the two most common ways that I get the question. And I get this so many times that it's finally worth it to do a video, I guess. The issue of recording somebody over the phone is completely different from the issue of recording somebody in person. And I'm talking about how the law sees it. They have two separate standards on recording you over the phone. I guess I don't know what they call it, wiretapping or something. I mean, those are where the laws are stuffed under. The wiretapping laws deal with that. And then, of course, recording somebody not electronically in person, which is weirder than you think because there are situations. I mean, that's what I guess I was going to talk about, where a person has a device that's attached to them or their vehicle or something, and it's not really considered over the phone. It's following them, like physically. And that's come up in Nevada before. In fact, I had a video called Secretly Recording Your Ex, which I'm actually going to move to members only because it's not really relevant anymore because they changed the law. Um, and that's like even a third dynamic as to how to deal with the problem when it happens. So I guess let's just break these down and we'll start with the phone one. So remember, I'm not an attorney, and this particular area of law is extraordinarily complex. You wouldn't think it was, but it is. There's all sorts of different standards. The different states have different standards of those standards, and all I'm letting people know is sort of the different paths that you can take on doing your own research, sort of letting you know what exists as a concept. But there's not going to be any final answers in this video. That's going to be up to each individual viewer, or you can, if you have an attorney, just ask them. So over the phone, electronic stuff, that kind of recording, when it's voice, it's different than if it's in writing, as far as I know. And I'll talk about exceptions at the end. As far as I know, anything that's in writing can be used anytime. Again, I'll save the exceptions for the end. So like an email or a text message, there's this sort of this underlying foundational concept that you have a right to privacy when you can reasonably expect privacy. But when you're typing stuff out and sending it, you can sort of imagine that a reasonable person might imagine that your typed up words could conceivably be shared with other people. Like, look, this is what they sent me. Versus audio stuff, where you may want to speak candidly with somebody, not thinking that you need to do all of this checking up before you speak because your words are going to be recorded and put somewhere or used against you in some way. So as far as I know, and somebody correct me down if I'm in the comments if I'm wrong, with barring the exceptions that I'll talk about at the end, emails and texts and stuff like that, Facebook Messenger, you can't, the public just generally doesn't expect that you can reasonably assume that that stuff won't be used again. I mean, you typed it out. So for the voice stuff, the communicating by voice, there are different rules in different states. Some states say that both people have to agree. Some states say that only one person has to agree. The tricky thing is, what counts as agreement or consent? From what I have seen, if somebody tells you they're recording you and you don't agree, that doesn't mean they have to stop. That just means you have been notified and you can hang up. This is one of the things that confuses a lot of people is they think, hold on, they said they were recording me and I said they didn't have my permission and they kept recording. As far as I know, the law says you were notified. If you didn't like it, hang up on them. And I'm going to talk about in my own custody case. There was an order entered on this. I'll save that to the end too. You might be interested in how this happened in my own custody case. But yeah, that's one of the things. The other thing that's interesting is somebody will, this one's almost laughable. Somebody will say that they're recording the other person, typically their ex, hey, I'm recording you. And their ex will also record them back without telling them. And they'll get upset about that. Hey, I told them I was recording them, but they didn't tell me they were recording me. Well, you only have to be aware that the conversation is being recorded. You don't necessarily have to give like a disclaimer or like permission. So, as far as I know, the way the law sees it, if you're telling somebody that you are recording, the way the law sees it, you're aware that it's being recorded because you just told them you were doing it. So how can you expect the conversation to be private when you yourself told them you were recording them? That's one of the things that's interesting with these telemarketing companies or corporations. When I don't know if you've ever picked up the phone and it says something like, this phone call will be recorded for quality and reporting purposes, stuff like that, right? You don't have to tell them you're recording them. That's one of the things that is this is talked about on other channels. Like people who have recorded those phone calls with those companies only to embarrass them on like Twitter and Facebook, and people wonder like, oh my gosh, are you going to get in trouble? Well, no, because when the company called, it said right then and there they were recording me. So why would I have to tell them I'm recording them? They're aware. They just told me they were doing that. So that's another thing that's interesting. And you know what? I actually worked for a collection agency. I won't say which one because I don't want to out the guy. But he told me, because it came up at some point, why don't we record these calls with these debtors? Well, we don't want to do that because then they can record us without telling us. So I remember the owner of that company specifically saying, we don't record our calls with the debtors because we like that this stuff is not recorded. It can turn into evidence. So that was, that's not on accident. When you have conversations with companies that don't actually say we aren't recording you, I'm not just going to say it's a conspiracy with all of them, but with this particular company, it was expressly told to me by the owner. So that's as far as I know with regards to over the phone. Some people might be confused about this whole, wait a minute, one party, like only one person has to agree. That's confusing. I mean, that means the person who's recording can just not tell the other person. Right. That's exactly what it means. They can just not say it and just record you. And people get confused and say, well, what's the point of one person? Believe it or not, there are 0-person situations. People ask, what is that? How can nobody know? Well, a third person recording a conversation between two people who have no idea it's being recorded. It's not as common, but it does happen. So I think that's more of a situation that would alarm the public, that does happen. And those situations where a state says one person has to agree, I mean, that is actually a relevant law because you could be recorded by a third person having no idea that neither of you in the conversation having any idea that it's being recorded. So I mentioned earlier that in-person recording is different, and it is also in the eyes of the law. Like there could be a state that has 2-party consent for phone call and 1-party consent for in-person. I think that's Nevada even. So like in on the phone, both people have to be aware, but in person, only one person does. So they can have like a listening device like on them and record the other person, and that's okay because it's in-person communication. It might get weird if you're in a private area versus like standing in a parking lot or at a store or something. I mean, these are the reasons why I gave the disclaimers in the beginning of the video. This is stuff you have to check out. I mean, there may be reasons why it's different in person. Maybe there's less of an expectation of privacy in certain areas that you're talking versus in like a private area. This is stuff people have to look up. It's not that simple. And again, I think I mentioned earlier, there was a situation in Nevada, and I did the video secretly recording your ex, and that was technically an in-person recording because the device it wasn't an over the phone thing. It wasn't a communication over electronic devices. It was a device was planted in a child's backpack and sewed in there, so it was concealed. And so technically it was an in-person recording, but it was a zero consent sort of situation. because the father who had put the listening device in the child's backpack wasn't present for what he was recording. So the device was recording the mother and other people in the home and the child, and nobody had any idea that it was occurring. So that was a zero consent situation, and that went to the Supreme Court, and that published under, I think, a bid via bid, which I don't think is good anymore because of the changes in the law that happened after that case published. So that's another example of a zero consent situation, which is slightly not accurate because of something they call vicarious consent, which is, as far as I know, a federal concept. I know it's, with almost certainty, it's not a concept in Nevada that I have seen. I've seen the concept in federal court where a child can vicariously consent through their parent to being recorded. In which case, that technically wouldn't be a zero consent situation. If the child vicariously consented through the dad who planted the listening device, even though the dad wasn't there, the child was vicariously consenting. And that is not black and white either. There's case law that discusses when a child can vicariously consent to recording. And it actually, if I remember correctly, it talks about having custody of the child, having like a custodial declaration. So if I remember correctly, that would make it really suck to be the non-custodial parent, that the child can't vicariously consent through you, but they can consent through the primary custodial parent. More stuff to look up, more stuff to research. It wasn't really something that I dove into because it didn't apply in my own case. But another interesting concept. So there was a third situation, which was how do the courts deal with the problem? As far as I know, there's only 3 different remedies. One is monetary. Basically, you can sue for money. The other is jail. You can be convicted of a crime and go to jail, which is what happened in McDonald. So if you want to see an example of what that looks like, go to our Nevada judges and watch the state of Nevada versus Michael McDonald. Not the case in front of District Court Judge Ronald Israel, but the other case in front of District Court Judge Christina Silva. That's the trial on the wiretapping. So you can see in action, somebody recorded their ex without telling them. Then they were charged, prosecuted, and convicted of it. So money, the jailing, and then of course suppression, which is what came up in a bid via bid, the case that I talked about. And if you guys want to watch that video, secretly recording your ex, before I turn it members only, because once I do that, it won't be as easy to watch it. Though it's only like $2 a month, so I don't know why people aren't members. It's cheap. What was I going to say? Yeah, in a bid via bid, that was the issue that came up, is suppression, is to keep the evidence from being used against you because it was obtained in violation of the law. And what I remember from a bid via bid was that the Supreme Court said that it was not, well, they just published case law, rendered an opinion saying that we weren't going to allow you to suppress in these context of a child custody case because a child's best interests and their welfare trump the fact that the law was broken to obtain that evidence. The Supreme Court, however, did say that you could be punished civilly or criminally for doing that. So even though they were going to let the evidence go in and allow the family court judge to consider the evidence that was unlawfully obtained, you could still be criminally and civilly held liable. And in fact, that did happen. I don't think Mr. Abid was prosecuted, but I know for sure that he was sued for money by his ex. So the case went into federal court. She sued for money, and I have no idea what the outcome was. I think it's settled. But it just goes to show you that even if you can't even if the evidence isn't suppressed, because that's what's good for the child, they want to make sure they can take care of that child in case they were being abused or molested or something horrible. And it did impact the custody decision in that case. The dad ended up getting primary physical custody based on those recordings. The mom was found to have been doing some pretty egregious stuff. However, she just turned around and sued him for money. And that's exactly what the Supreme Court warned could and did happen. So those are the 3 sort of things that I wanted to go over. I mean, the difference between recording over an electronic device, the difference between recording in person, the concept of being aware doesn't mean that you can say, hey, I demand that you don't record me and we get to keep talking. From what I've seen, the court expects you to just hang up. Just stop talking. If you don't like it, shut up. So now I'll go into the exceptions. There are exceptions, of course, like attorney-client communications. Like an attorney has to preserve your communication. That's a separate concept. And, patient client, patient doctor. So the doctors and the lawyers are bound to different confidentiality rules. As far as I know, their clients and patients aren't. Settlement communications, mediations, these are separate principles. I mean, if you show up at a settlement conference or a mediation and you try to tell them you're recording them, they're going to tell you to stop, because there are these separate principles that are in support of settlement, being a confidential thing. And if you don't comply, they're probably not going to continue with the mediation or settlement. What they'll probably do is just cancel it, and then you'll get punished by the court for a completely different reason under a completely different basis. So there are these sort of other concepts where you could be forced to communicate in private. If you're a doctor or a lawyer, that's just part of the job. If you're going to mediation or settlement, that's just part of the legal system, wanting to facilitate settlement. And so there are these other concepts out there that deal with that problem. The last thing I did say, I promised you guys I would tell you how this came up in my case, and it did come up in my case. So I remember it being brought up by my ex that he's saying all these things, and then he comes to court and he says different things. And I guess her lawyer said, can we just have the right to record him? And the judge said, yes, from now on, you both have the right to record each other. And at first I was like, okay, that's great. She's going to be a lot better now. I mean, she was lying about me saying anything bad. I didn't care about it. I've been lied about so many times, I just didn't care. I saw it as a mechanism that I could use in the future, which I don't think I ever used. Not even once. But I did keep in mind that she could be recording me, which is something that I always thought, even before that point. And so I always made sure to keep my communications gray rock. So later on, it kind of bothered me. I was like, I don't like that this judge said she has the right to record me because of like generic sort of understandings of like the Constitution and stuff. I'm smiling now because all these years later, I just changed my opinion again, because I realized that's just not really how it works. It's not like you have a right to record other people as much as they may have a right to just be aware of it. That's all. And so even though the court wrote down in the order using language that was pretty confusing, I can see now that what it did is just satisfy the notice part of recording. That's all it really did. So I see the court order differently now than I did, in the beginning and towards the middle of my case. It's like, now I just see it as the court making us both aware that we're being recorded at all times, which is totally legitimate. It's totally, as long as you're aware that you're being recorded, you can't really complain about it. And it makes sense. Like if you sweep away all of the laws and you just think about it in principle, if you're aware you're being recorded and you're aware your words are going to be used against you, you're just going to be more careful about how you communicate. You're going to be more accurate. You're going to keep in mind this can be used against me. You're going to speak more, maybe more eloquently or in less candidly. That's truth. You're not going to be as candid because you don't want your words to be weaponized. So it's going to be more of a conveying of information and less of a sort of emotional, happy, fun social connection like you have with your friends and stuff. Well, you can say all kinds of nonsense. You can be as candid as you want with your friends. Nobody's going to put your stuff on social media or sue you. And that's a very healthy, important part of society, honestly. When I started to run the Nevada Judges Organization, it makes it difficult to figure out what's going on if you constantly feel like everyone's recording you all the time. Candid relationships with sources is vital. And so when you're not really doing this kind of stuff, it might seem odd to you. You might be like, why do people care so much about being recorded? But when you start to see what it's like, when it becomes a professional thing, you could sort of see, okay, I can see now why journalists and business people and stuff, this is a vital thing. You need to be able to communicate candidly. It's not just a nice part of life. It's an important part to running your business or doing your journalism stuff like that. It becomes more obvious why, or, for politicians and stuff. You have to have both modes available to you. You just do. You can't just always feel like you're recorded all the time. It kind of chokes your ability to gather information and figure out what's going on. So it's really one of those things that I think the general public might not understand if they're not in that line of work. But the people who are in that line of work, whether it's politics or journalism or business, they can probably very clearly understand why they need to be able to communicate that way sometimes with some types of people. So I guess that's all I have, guys. Probably a better video than I thought it would be. If you have any questions, feel free to post them down in the comments below, and I will see you guys next time.